All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Thank you, Mr. Soar. Good morning, everyone. Welcome to the Court of Appeals on this frosty morning. My name is John Tyson. Your panel today, to my right, is Judge Jeff Carpenter. To my left is Judge Fred Gore. We have two cases on the docket today. I think they have been consolidated for argument. And if there's nothing further, let me introduce Gene Soar, our clerk of court, and Richard Remilliard, who is our security officer. Thank you all for being here today, too. If there's nothing further, we will hear from the appellant. Good morning.
Good morning. Thank you, Your Honors. My name is Sam Mcgee. I represent the plaintiff appellants in these two cases that the court's been kind enough to consolidate for argument. I intend to reserve 5 minutes of my time for rebuttal, and also, as you know, I have ceded 5 minutes of my time to the state of North Carolina, who filed an amicus brief in this case.
Okay.
I am representing two clients here today, both of whom were sexually abused as children repeatedly by Catholic priests. One, John Doe, was an altar boy raised in the Catholic Church and was groomed and abused by a priest named Farwell. The other, John Doe 1K, was brought to the Catholic Church as a young, troubled teenager by his grandmother in search of pastoring and mentoring, and he was abused by a priest named Father Kelleher. Criminal charges resulted in both cases. Farwell pled no contest to charges that arose from the abuse of a different child. He is still living and I believe is in Florida. Kelleher died with criminal charges still pending against him from my client's allegations. Now, as you know, these are two men that brought their claims previously, which will be different than some of the other Safe Child Act claims that this court will probably one day have the pleasure to hear. Two things have happened since they came and did that. Their cases were dismissed on the statute of limitations at the summary judgment stage when they previously brought their claims. Two things have happened since then. One is that the Roman Catholic Diocese of Charlotte released its list of credible allegations of sexual assault. These two clients that I'm representing today, both of their allegations against these priests were listed by the diocese as credible allegations. The second is that the Safe Child Act was passed. When the Safe Child Act was passed, what happened was our legislature realized that its own rule, a legislatively created statute of limitations, failed to recognize the reality of when victims of child sexual abuse come forward. 52 years. 52 years of age is the average age that a victim of childhood sexual abuse comes forward. And the statute was basically, you had to bring your claim by the time you were 21 years old. So what our legislature did was try to remedy that problem in its own rule. And they didn't extend the statute out beyond 52 years, but what they did say is, well, here's a 2-year window, which ends here in a couple of weeks, that you can bring your claims even if they were previously time barred. The wording of that window, which is important, is that it revives any civil action previously time barred by the statute of limitations. Now, the main issues that I want to talk about today are the constitutional issues for the Safe Child Act. I do want to speak briefly about the 3-judge panel issue because I did have a motion to transfer that was denied by the trial court. One reason I want to keep that fairly brief is because I'm well aware that 2 of the judges on this panel issued opinions on that issue within the last 3 weeks. And so I know that I'm speaking to some folks that are well informed about this issue. Judge Tyson, I'm sure you are as well.
I have a copy of the opinion in front of me.
I will say that I do believe that this particular case is distinguishable from the Cryan case because that case dealt with the criminal portion of the statute where you can bring a claim within 2 years of a criminal conviction. That could apply to people whose claims are previously time barred or not. So I think it's easier to say that you could have an as-applied challenge to that portion of the statute than you can for the 2-year window. The 2-year window that we're here about today only applies to claims that were previously time barred. So I think it's a lot harder to have an as-applied challenge as opposed to a facial challenge to this portion of the statute.
Mr. McGee, I'm sorry, go ahead.
No, sir, you're the senior judge.
Is there, between the two cases that have been consolidated, is there really any material differences in the two?
I don't believe there are that will affect the legal issues we're here to talk about today. If something comes up and I feel the need to draw a distinction between the two, I'll do so, but for the most part, I believe that they're in line legally.
Thank you.
The only other thing I want to
Judge
mention...
Carpenter, I think, had a
Oh,
comment.
I'm sorry, sure.
You said that it would be harder to carve out a class that it wouldn't apply to. How could you carve out a class that it wouldn't apply to? Given the language of the statute.
I don't think you can, because literally the statute says it revives all civil actions previously time barred. When the initial motion to dismiss was filed, they cited Wilkes versus Forrester. It didn't label it as applied or facial at that time, as I think they may have in Cryan, but they just cited Wilkes versus Forrester. Wilkes is a case that we'll talk about a lot today, but it did not deal with a situation where there had been a previous case filed or something of that nature. I think there's some arguments in this case that have to do with the fact that there was a prior judgment, and some that are just based on the fact that the statute of limitations had lapsed. But if you look at the actual motion that was filed, the only authority it cited was Wilkes versus Forrester, which is not a case that involved a prior judgment. So given that, and there's a whole section of their brief which is arguing about why this entire window is unconstitutional, whether or not there was a prior judgment. So I think that's a facial challenge.
So I understand that portion of your argument, counsel, but let's look at pleadings. So are you saying the context of their arguments should be looked at as a facial challenge, or that there's pleading that clearly delineates it as? Because in looking at your briefs, it seems like your argument is that if you look at the argument, you have to look at it as facial, versus the pleadings, as the statute require, have pled it as facial. Help me get to where you are.
I think when they originally filed the motion, they didn't make any delineation about that at all.
Which is required by the statute, correct?
Right, and so I think what we have to look at is, what is it really?
Okay.
What are the, you can call a goat a horse, but it's still a goat.
Well,
And so
you could argue a pig is a goat, but at the end of the day, it's still a pig. So that's why I'm trying to get you to, on the documents and looking at the letter of the statute, help me, because there's no complaint or amended complaint per statute that has a facial challenge.
Right.
The motion is the only thing I think really that is at issue from your argument. But on the face of the motion, and I think you very validly said that it does not appear, but your context of your argument, and I'm just making sure I'm understanding it, is that to go to the extent that they are, you have to look at it as facial, because on the face of it and on the pleadings, it is not documented as facial. Am I understanding how you're...
I am saying that what they make initially is a facial challenge because it says that any retroactive statute of limitations is unconstitutional and cites Wilkes versus Forrester. And that's a facial challenge. So because it wasn't stated what it was one way or the other, I think we have to look at what it really is, and I think it's a facial challenge.
And who is the decider of that? Is it the trial judge to make that determination if it's not pled facial versus applied?
I think that would initially be the trial judge, but I also think that would be an issue for this court.
Okay, all right, thank you.
So what I want to do is, and I'll reserve further arguments about that for rebuttal and move into the substantive issues in the case. Briefly, there are a couple of issues they say that keep us from getting to the constitutional issues. One is res judicata. We're going to talk about that plenty within the context of separation of powers, but basically, they argue that you can just straight up dismiss this case based on res judicata. Here's the problem with that. What the 2-year window says is it revives any civil action previously time barred. It's not saying not if there's a prior judgment. It's not saying only if there's a prior judgment, but by on its face, this statute revives previous civil actions. So the res judicata issue is subsumed by the constitutional issue. We can't say, well, it's just straight up res judicata, because what the legislature has said here is not here. They're trying to fix a problem with a rule that they made, and they're saying we're reviving these civil actions. We can talk about whether or not they have the authority to do that, but that's a constitutional issue.
Let me make sure I understand what you're saying, Mr. Mcgee. You're saying regardless if there has been a prior adjudication or the claim was never brought timely, same result or different result?
I'm saying same result, whether or not there was a prior case. And Right now, specifically what I'm saying is, there's not a res judicata issue that is separate from the constitutional issue
On either one?
on either one.
So there are no claims that were ever brought, that basically they all would have been barred by the statute of limitations but for the legislation. Is that what you're saying?
That's correct. And that's what was ruled in the previous litigation. So what I'm saying is there's not a res judicata argument that's separate from the constitutional argument, because the statute on its face essentially creates an exception for res judicata for these cases that fall within the scope of the Safe Child Act.
Would there have been a difference if a prior claim had been brought and had been adjudicated by dismissal?
I think if we had gotten to the merits of the claim, whether or not the abuse happened, whether the diocese could be held responsible, I think if that had been litigated, then I don't think the statute of limitations issue would matter. Given that the merits were never reached on these cases and that they were dismissed specifically on the statute of limitations, which was a legislative creative rule that the legislature has now changed, I think the result will be different. Because of that, I was going to start with the law of the land clause, but let me just go ahead, since we're kind of on the topic, and go straight to separation of powers, because that involves the res judicata issue more directly. Two initial observations on the separation of powers. Number one, all the legislature did was change a legislatively created rule. Number two, there is no case that's been cited in this case that has found that a retroactive statute of limitations creates a violation of the separation of powers under the North Carolina Constitution. As you know, courts apply the law as it stands. Here, the issue was not some substantive law, and we'll talk about some cases where the substance of the law got changed, but the law of access to the court, a law of procedure. All that changed was the statute of limitations. Can you bring your claim? So this is not a situation where the General Assembly said, hey, courts, you got this wrong, or you interpreted our rule wrong. The General Assembly is saying, we got it wrong. The legislature passed a rule. It realized its rule was leading to unjust results. The 52 years, the fact that this kind of abuse keeps people from coming forward, the legislature said, let's bring our statute of limitations for these kind of claims within modern understanding of what this kind of abuse does to you in preventing you from coming forward earlier. So the legislature decided to fix this problem by changing its own rule, not a court's interpretation of it, but its own rule. And their way of fixing the damage that had been done by that rule is to say, well, let's give these folks a 2-year window so that they can try to bring their claim so that they might one day be able to actually get into a courtroom on the merits of their claim. And I don't see how any of that violates a core function of the judiciary. Now, there are several cases that we have cited, that they have cited, and frankly, some of them are contradictory to one another. So if we start, for example, the Wharton case, that was the case that had to do with bonds. And there were some bonds that the Supreme Court said are illegal, and then the legislature changed it. And it came back to the Supreme Court with the question of, well, can they do that after we've had a final judgment? And the Supreme Court said, yes, they can do it. Now, the defense says that's only so because that case was still pending on remand. Well, that argument is undermined by one of the cases they themselves cite. The Gardner case, which was this domestic case where there were changes to the venue rules. And while that case was still pending, this gentleman tried to change the venue to his desired county, and they said, well, no, you can't change that. And that's been later shown by the Stevenson court to be because the case was pending. So we have some cases where you were able to change the law while the case was still pending, and some where you couldn't. So there's no bright line rule in North Carolina. And remember, there is a presumption of constitutionality and deference to the legislature, but there is no bright line rule in North Carolina which says that you cannot change a piece of law after there has been a judgment.
Let me ask you this. Do you agree that the diocese or the Catholic Church's liability here is vicarious?
Well, not entirely, no, because we believe it's not just that they were the employer of someone who did these things, but it's also the fact that failure to supervise, the retention of these people after they realized that there were problems. So I do think that there's direct action that they engaged in that led to these results.
Could you see a situation where, in a vicarious situation, that it would violate due process or some type of fundamental fairness to hold a vicarious party liable long after an event occurred so that evidence is gone, people have died, they really don't have a means to defend themselves? Can you imagine a situation where that would be subject to a challenge? A fundamental fairness or fundamental procedural challenge?
I don't, Your Honor. I mean, we're the party with the burden of proof. And all the time, the longer it takes to get a case to the court hurts us more than it does the defense, because we're the ones that has to prove our claim. So when evidence fades, when time goes by, it makes it harder on us than it does them.
Well, you notice one of the perpetrators has died.
He has. His deposition was taken before he died. I took it myself, but I certainly understand that. But I would say, and again,
If you had not taken that, could there be an argument that basically the church has been deprived of an ability to defend itself
I don't believe
through
so,
long
Your
periods of delay?
Honor. And I will say, I think, and this gives me an opportunity to, because when you start talking about, fundamental fairness or any kind of vested right, that kind of switches us back over to the law of the land clause argument.
Right.
And one of the ironic things about that argument in this case, if we're talking about the most fundamental rights in this country, free speech, free exercise of religion, interstate travel, voting, any of our rights, most fundamental, can be taken away from us by legislation that passes strict scrutiny. The cases that the defense relies upon here essentially says that there is no level of scrutiny. It elevates the right to not be sued when a statute of limitations has passed above free speech, free exercise of religion, or voting, because any of those you have to pass strict scrutiny, and they're saying here that there's no scrutiny. Now, how did that happen? That happens because of this Wilkes versus Forrester case. It's an interesting thing that happened, and I talk about it in the brief, but generally we follow federal law. We absolutely follow federal law in the federal Constitution, right? And then we generally follow federal law for our law of the land clause jurisdiction. We follow substantive due process of the federal courts. But what happened here was the Wilkes versus Forrester court, and it's just an unfortunate thing, they quoted an exception of Campbell versus Holt, which is the Supreme Court of the United States, as the rule. So they took a counterexample as the actual opinion. Campbell versus Holt was saying a retroactive change to the statute of limitations does not violate due process. And then they mentioned as an exception to that, well, if there's title to a real property or a tangible personal property that has vested, then that's an exception. The Wilkes court took the exception as the rule, and then that's kind of drifted down through our courts. So we have this odd situation now where even though the federal court, and it was talking about the federal Constitution, not the state Constitution, where where the federal courts have said this does not violate due process, and where one of our courts said it did. And it also creates a second irony, which is that we have generally always treated statutes of limitation as procedural, and you generally do not have any vested rights in something that's created by procedure. But now, because of this misquote of the Supreme Court of the United States, we've accidentally elevated the notion of a procedural right above all the fundamental rights that we have in our society: free speech, free exercise of religion, etc. So what needs to happen here is that this needs to be analyzed for the first time by our courts through normal constitutional scrutiny, whether it be rational basis or strict scrutiny. Now, my contention would be this is rational basis scrutiny because this is not a fundamental right like free speech. Rational basis scrutiny is not very hard to pass. It has to be rationally related to a legitimate government interest. Here, it's clearly, there's many legitimate government interests here. It could be holding people accountable for sexual abuse. It could be giving folks like my clients their day in court. It could be getting the names out there of abusers. There's a lot of things that are compelling interests, I would say, not just legitimate interests. And this is a rational way to deal with that. The legislature saw a problem. Our rule was keeping people from getting their day in court. We're going to give them their day in court. And if anything, this law, in my opinion, is too narrowly tailored because it only gives people a 2-year window, right? And I would say this even passes strict scrutiny, which again, it has to be narrowly tailored to a compelling interest. I think these interests I've just listed are not just rational, but are compelling, and this is a narrowly tailored result. They didn't take the statute out to 60 or say there's no statute of limitations for this at all. They just said, here's a one-shot deal, as Representative Riddell called it. You've got 2 years to do this, to bring your claims, and for the first time ever, to have your day in court.
When do you contend the 2 years starts to run?
Well, frankly, Your Honor, I haven't looked at how the statute of limitations stay that we had for COVID might affect it, but the statute creates a specific 2-year window that ends this New Year's Eve, and it had started 2 years before that.
So what is the triggering event that starts it to run? Is the conviction?
No, on this
Criminal
one,
conviction, or what, that's where I'm trying to get.
okay, I understand. There's a different part of the statute that triggers a different 2-year window upon a criminal conviction. But what we're talking about here is the general 2-year window for older claims. So the statute got pushed out basically from age 21 to 28. But then because the legislature realized that wasn't going to reach everybody who hadn't gotten to have their day in court under the old law, they said, hey, here's a one-shot deal. You've got 2 years starting from January 1st of 2020, ending 12/31/21, and even if your claim's older, you're over 28, we're going to allow you to bring your claim within that 2-year window. And there have been a good deal of claims, a good number of claims brought. A lot of them are pending. Some are in 3-judge panel. I know Cryan has come before you guys.
So the triggering date is nothing more than a date certain, 1/1/20.
It's a date certain in the statute. That's correct.
Thank you.
I'm through my initial 20, and I'm going to defer now the 5 minutes to the state.
Okay, that's fine. Mr. Rubin?
Good morning. May it please the court. Philip Rubin on behalf of the state. And on behalf of the state, I'm appreciative of the court's willingness and the appellant's willingness to let us present this morning as amicus counsel. I plan to spend most of my time on the legal issues that are before this court, and I think I should. But at the beginning of this, I feel like I must observe how important and compelling protecting the state's children is as an interest of the state. And this court and the Supreme Court have said that before as a compelling interest, protecting the physical and mental well-being of children. And I was kind of stunned to work on this matter and learn that as many as a quarter of girls and 1 in 13 boys are sexually assaulted as children, and that among the many horrible lifelong effects of that abuse is an inability to come forward in time to seek any kind of civil justice for that abuse. And we're here today to address, the court may reach at least, the legislature's unanimous decision that it should right that wrong by providing an opportunity for relief. And picking up where Mr. Mcgee left off, this is section 4.2b of the act. It's an uncodified portion. And that portion allows anyone to bring these claims for this hard-coded 2-year window that ends in just a couple of weeks. Now, in thinking about that constitutional challenge, which is what the state addressed in its brief, I know there are other issues, but in thinking about that challenge, it occurs to me that there are really only 2 ways in which a court may find an act of the General Assembly to be unconstitutional. The first way is a law might rely on authority that the state constitution specifically denies to the legislature. Of course, our state constitution is not a grant of power to the legislature. The legislature has whatever power the Constitution does not forbid it. And so courts will only find a power to be lacking in the legislature if our Constitution explicitly or by necessary implication denies that to the legislature. Now, of course, there is no explicit prohibition in our Constitution on reviving statutes of limitation, unlike some other states. And what we do have in the Constitution implies that there is no such limitation because we have an ex post facto clause. And that clause prohibits not just the standard criminal ex post facto laws, but it goes further and does prohibit one kind of civil statute being retroactive, certain taxes. The absence of a prohibition on statutes of limitations is a structural indicator that our Constitution does not intend to deny that power to the legislature.
Does the state see a scenario where the passage of time can so prejudice a party, a private party, that there would be a constitutional issue with an unlimited statute to bring a claim?
I don't think so, Judge Tyson, and recognizing that in the law every scenario under the sun eventually comes up, and we may have to confront that as it comes. Certainly on a sort of across-the-board challenge, I don't think that would weigh into it because I don't think that would happen most of the time. But I think Mr. Mcgee's answer actually answered it the way the state would, which is, first, the burden is still on the plaintiffs. The burden has not changed. And frankly, the loss of evidence is generally going to harm the plaintiff. And that, second, in these cases, the state has no statute of limitations on felonies, for example. And that, I don't believe, has ever been held to violate due process. There's just still a burden of proof, of course, a higher one in criminal law.
Well, we have equitable principles of laches and estoppel that basically punishes delays of a party bringing a claim. That's a fundamental unfairness to a party in not being able to timely defend. So why wouldn't those equitable principles still be applicable here?
I don't think they would be applicable at a minimum in this case, which is a, you know, and I have to agree with Mr. McGee, a facial challenge saying the legislature cannot revive statutes of limitations, full stop. And so, in other words, Judge Tyson, if that were to come up in a case, that'd be a very fact-bound determination.
So it'd be an as-applied challenge.
It would be as applied, and it would be very deeply tied to the facts of a particular case. And
Such as the death of a person?
such as the absence of available evidence. And I will say, I'm not suggesting that the state thinks there's necessarily a time when that would rise to the level of a due process problem. But I will say that if that issue ever came up, it would come up in a fact-bound way tied to the specific
Well,
facts.
since this is a civil action, correct?
Yes, Your Honor.
The equitable principles of laches and estoppel still could be asserted here, could it not?
Possibly, but not before Your Honors today in this case, because it's not one of the issues that's in front of you. Instead, the request is.
If it's an as-applied challenge, it's before us, correct?
If it is, I don't believe they've raised it as sort of a latches type of argument. I think it's raised these cases that we're talking about, Wilkes County, Waldrop. Those are not latches. Those are not equitable. Those are legal determinations about a lack of legislative power to do something. And so if that's the argument, those principles I don't think would apply there. I do see my time has expired.
I'll give you a moment to sum up.
Of course, thank you, Your Honor. I'll just say very quickly, the other way a law might be unconstitutional is that it infringes on a right and fails the test. And that is what Mr. McGee addressed, that why would we elevate the expiration of statutes of limitations above fundamental rights that get modern substantive due process analysis? And we would submit, if you apply that here, that you should uphold this statute, and it's a crucial, crucial interest for all of our children.
Thank you.
Thank you, Your
Mr.
Honor.
Rubin. Here from the appellee. Good morning.
Good morning, Your Honor. Thank you, and may it please the court, Joshua Davey of the Charlotte office of the Troutman Pepper Law Firm, here on behalf of the defendant and the appellee, Roman Catholic Diocese of Charlotte.
Who's your co-counsel?
This is my co-counsel, Kevin Leroy. He's from our firm's Chicago office, admitted pro hoc vice in these matters.
Okay, thank you.
Thank you, Your Honor. We heard...
Do you plan to divide your time?
no, Your Honor. I'm going to take the whole argument.
Okay, thank you. You may proceed.
Thank you, Your Honor. We heard from appellant's counsel a moment ago and from the state a good bit about Wilkes County and about whether this court must follow the binding precedent of our state Supreme Court in that decision. And I think the court has to do that if it reaches that issue. But I think the court should affirm the judgment of the Superior Court and doesn't need to reach the Wilkes County issue. And here's why. I think that this case is an open and shut case of res judicata. I don't believe the revival provision that's set forth in the Child Safe Act actually applies to the claims in this case, which I'll get to. And those are issues of statutory construction, which don't implicate constitutional questions.
Mr. David, do you see any factual differences between the two cases?
Judge, I was thinking about that question you asked Mr. McGee. I think the only difference I would point out to the court is that the Doe 1K case was affirmed previously on appeal by this court, whereas in the Doe case, the plaintiff did not appeal the decision of the Superior Court back in 2014. It doesn't matter for purposes of the res judicata effect of those prior judgments. So from a legal standpoint, no, but I did want the court to be aware of that difference.
Thank you.
So let me address the res judicata argument. As the court knows, res judicata is a bedrock principle of our legal system, and it applies when there's three elements satisfied: a final judgment on the merits, an identity of causes of action between the first case and the subsequent case, and an identity of the parties in the two lawsuits. Those elements are all met here. As the court can see in the record, there was a final judgment in the Doe case in 2014 from Judge Bell in Mecklenburg County that was not appealed. And then in the Doe 1K case, this court again affirmed the dismissal on appeal in 2015.
Is the dismissal based on the expiration of the statute of limitations a judgment on the merits in your view?
Absolutely it is, Your Honor. And I heard counsel for the appellant make the argument that a judgment based on the statute of limitations is not entitled to res judicata. That is wrong as a matter of law, Your Honor, for a couple of reasons. First off, I'd cite to the court Little versus Hamill, a decision of this court, 134 NC App 485, in which this court gave res judicata effect to a prior judgment that was based on the statute of limitations. It's a well-established principle. I'd also point the court to Rule of Civil Procedure 41B, which provides that any judgment any judgment that's not provided for specifically in that rule, which includes a judgment under Rule 26 for summary judgment, is a judgment on the merits. The difference between a judgment on the merits and a judgment that would not be entitled to res judicata effect is that those types of judgments deal with things like a lack of jurisdiction or voluntary dismissal, and they're specifically provided for in Rule 41.
So this difference between the dismissal with and without prejudice is what you're saying?
Yes, Your Honor. Rule 41 provides that a Rule 26 judgment for summary judgment is a judgment and adjudication on the merits unless the court provides otherwise in the order, which did not occur here. And I'd also cite the court to Caswell Realty Associates versus Andrews. That's 128 NC App 716, another case where this court said a summary judgment is a judgment on the merits. So I think that's thoroughly established. If there's any doubt about that, another point of guidance that I'd suggest the court consider is the Supreme Court's decision in the Plout case, the U.S. Supreme Court's decision in the Plout case that we cite in our brief. And that is, it presents the exact same question at issue here, where there had been a judgment, there had been a change to the statute of limitations later, and the parties were arguing about whether or not that change to the statute of limitations could reopen that prior judgment. And the United States Supreme Court said no, because that final judgment, even though it rested on the statute of limitations, was entitled to res judicata effect. And in fact, the Supreme Court in that case took on the very kind of procedure versus substance distinction that appellant's counsel is trying to advance here. And what the court said, I think, is illustrative and ought to guide this court as well. They said there are lots of different kinds of procedural rules that can change. One example that Justice Scalia in that case pointed to are pleading rules. Clearly, the General Assembly could come along in North Carolina and either raise or lower required standards of pleading for a claim. And if the appellant's argument is correct, that a change in a procedural issue like the pleading rule can reopen a closed final judgment, think of the mischief that would result. All the judgments that would be subjected to be reopened, and the damage that could be done to the separation of powers and to the integrity of the judicial department in the state. So for all those reasons, I think there's no question, Your Honor, that a judgment based on the statute of limitations is entitled to res judicata effect.
Counsel, on that issue, as you form that argument, imagine the mischief on all of the context of that argument seems to be a broad application, which has tones of facial challenging the issue versus as applied to this case, which is what counsel for the plaintiff is arguing. So using your own words, it sounds like the context of your challenge is facial.
Well,
help me get back to your argument in light of what you just said.
yeah, Your Honor, I think there are several layers to our argument. There's some statutory layers about what does the statute mean, which I'll get to in a moment. And then there's really two constitutional issues that are embedded here. One is the separation of powers problem, and that is that if the General Assembly comes and voids the res judicata effect of a prior final judgment of this court or of the Mecklenburg County Superior Court, that is a separation of powers problem where the General Assembly, just as a structural matter under our Constitution, doesn't have the power to do that. That's not a facial challenge.
To undo a judgment. Is that
Correct, Your Honor.
That's
To
what
undo
you're
a final judgment, yes.
so is that an as-applied or is it facial?
It's an as-applied challenge because what we're contending there, Your Honor, is that if this court were to interpret 4.2b, which is the revival provision, in the manner suggested by the appellants and by the state, if that were to happen, then as to those claims that had previously been barred by res judicata, like those present before the court today, as to those claims, that would be an unconstitutional separation of powers problem. And that's an as-applied challenge. The other constitutional argument...
I'm having a hard time following the as-applied approach. What, as applied, that means there has to be a class that would fall outside, right? So what judgment would the legislature be able to set aside to get you to the as-applied? Why is it not just a straight facial challenge?
So, Your Honor, there I think we have to go back to what the revival provision says. And it says this section revives a civil action time barred by the previous 3-year statute of limitations. And what we're saying there is if the court were to construe that provision to void final judgments, then that would be unconstitutional. And that's as applied as to this case, because this case involves prior final judgments on the merits. For the purposes of the separation of powers argument, we don't need to say that there's no constitutional application of that provision. It's just unconstitutional as applied to void prior final judgments.
So you're saying that if the claim had not been brought in the 3 years, no ruling, that then an assertion of the unconstitutionality of the statute by a claim that never been brought, that would be a facial challenge, correct?
Your Honor, I think that's still an as-applied challenge for the same reason that applied in the Cryan decision, and what the court said in Cryan is that because the defendant, I guess, there contended that the statute was unconstitutional as to claims that had previously been time barred, then that was as applied, and I think that's the same here. But I think that's also the very last issue in the case, and that even if the court disagreed with us on that and believed that that was a facial challenge, it's not an issue that the court needs to reach in order to affirm the judgment of the Superior Court here.
You're contending that in both these cases, there has been a prior adjudication that's binding,
Yes, Your Honor.
that the legislature cannot undo.
That's right, Your Honor, as a matter of separation of powers. And I would also point out, Your Honor, that I think the separation of powers issue comes into play both as a straight-up structural limit on what the General Assembly can do, as well as an interpretive principle. If you read Section 4.2b, what it says is that this section revives a civil action otherwise time barred under the prior statute of limitations. The statute doesn't even purport to undo final judgments. It says it revives a civil action otherwise time barred under the statute of limitations. And I think as a matter of statutory construction, what this court is obligated to do is attempt to give the statute a meaning that does not put it in conflict with the Constitution. And so to read the revival provision in a way that would void final judgments creates this constitutional difficulty. And I think the court can solve that as a matter of statutory construction by holding that the revival provision does not apply to claims that are already res judicata, where there is a prior final judgment. And I think this is thoroughly embedded in the Constitution, and I would point the court to Article 4, Section 1 of the Constitution, which says the General Assembly shall have no power to deprive the judicial department of any power or jurisdiction that rightfully pertains to it as a coordinate department of the government.
If the dismissal of the summary judgment was based strictly on the running of the statute, are those category of cases different than if no claim had ever been brought?
It would not be different from the standpoint of res judicata. Now, as a factual point, Your Honor, I would point out here that the underlying judgments in these cases were not based solely on the statute of limitations. And in fact, this court's decision in the Doe 1K case, if you look at footnote 2 at the end of the case, what the court noted is that the plaintiff in both Doe 1K and in Doe actually abandoned a number of claims at the summary judgment stage in the Superior Court and told the Superior Court Judge Bell that the plaintiffs didn't object to the court entering summary judgment on those claims. And as to those claims, Your Honor, I think the issue is not the statute of limitations. The plaintiffs just abandoned those. And so what you have with the underlying decisions here is a hybrid. It's partially based on the statute of limitations and partially based on the plaintiff's own abandonment of those claims. And I think those judgments are absolutely entitled to res judicata effect. Your Honor, another point I'd like to address is this argument we heard from the appellants and from the state that the court needs to apply strict scrutiny or rational basis or some type of balancing test to evaluate whether or not the enactment of the General Assembly here can pass constitutional muster. And that's wrong. And it's wrong for the reason that counsel for the state just articulated. The courts can find that an enactment of the General Assembly is unconstitutional if it exceeds the authority of the General Assembly. And that's what we have here, because we have a situation where if the statute's interpreted the way that appellants suggest, then the General Assembly would be voiding the final judgment of the judicial department in these cases. And where the General Assembly acts outside its authority, we don't apply balancing tests to those kinds of enactments. It's a structural limitation on the authority of the General Assembly. To give you an example, if the General Assembly passed a statute that purported to override a gubernatorial veto, but without the necessary 3/5 majority required by our Constitution, we wouldn't be here asking whether or not the General Assembly had a compelling reason to do that, or whether or not the legislation was narrowly tailored. It would be unconstitutional because the General Assembly doesn't have that authority. And the same is the case with respect to undoing final judgments of the judicial department. And this, again, is the Plout decision that I would point the court to, which, although decided under federal law and the U.S. Constitution, I think is on all fours with this case.
We like to consider ourselves a branch and not a department.
Yes, Your Honor, thank you. I think the Constitution uses the term department, but I think branch is certainly the more modern usage.
Thank you.
So, Your Honor, let me turn then to another reason, another statutory construction reason why the court does not need to reach the constitutional issues in this case. And I think the court can and should read the revival provision and conclude that it simply doesn't apply to the appellant's claims here.
Are you expressing any opinion on the revival as to claims that have not yet been brought?
Your Honor, I think that is not the case before the court. Certainly, that might be a case that's here, and I think under the Wilkes County case, if the statute of limitations bar is complete, even if the claim had not previously been asserted, then that claim cannot be resuscitated. That's what our Supreme Court said in Wilkes County. But again, that's not the case before the court today, and the court need not reach that conclusion in order to resolve this case. And one of the reasons is that by its text, Section 4.2b, and again, that's the revival provision on which the appellants rely in the Safe Child Act, that section applies to actions for child sexual abuse. Those are the words that the General Assembly used there. And if you read other parts of the statute, you see that elsewhere the General Assembly talks about civil actions related to child sexual abuse. So Section 4.1, for example, of the statute changes the limitations period applicable to these claims. Whereas previously, a plaintiff would have 3 years after attaining the age of majority, so in most cases until age 21 to assert these claims. Now the limit is age 28. And what that section says is that a plaintiff may file a civil action against a defendant for claims related to sexual abuse, until the age of 28. Likewise, Section 4.1 contains the provision that was at issue in Cryan, which is the section that allows a plaintiff to bring a civil action for claims related to sexual abuse within 2 years of a felony criminal conviction for related sexual offense. And again, in that provision, the General Assembly used the words related to, and not a civil action for child sexual abuse. Now, the statute does not define for, and it doesn't define related to, but under basic principles of statutory construction, what the court should do is give those terms their ordinary meaning. And another basic canon of statutory construction is the court has to read that statute as a whole and try to give effect to each of the different provisions of the statute and give different meanings to different words when they're used in the same law. So applying those principles, I would submit that it's apparent that the General Assembly intended in these various provisions of the Safe Child Act to create a distinction between claims for child sexual abuse and claims related to child sexual abuse. So how does that matter here? The related to concept is broader than for. A claim related to child sexual abuse could include a claim against the perpetrator, who are not sued in this case, and it could include a claim against an employer of a perpetrator alleged to have somehow enabled the act or to have committed a breach of fiduciary duty or something along those lines. But by contrast, the civil action for child sexual abuse has to be given a narrower construction. And that's a narrower category, and the claims in this case are not claims for child sexual abuse, as to my client, the Diocese of Charlotte. We're alleged to have failed to supervise an employee or to have breached a fiduciary duty. There's no allegation that the diocese committed the acts at issue here. Now, and I would also say that while the court should follow the text of the statute, and that is...
the acts of the agents, the acts of the diocese?
I'm sorry, Your Honor?
Or the acts of the agent, the acts of the diocese?
No, Your Honor, because what's alleged here are intentional criminal acts, and the law is well established that an employee who commits an intentional criminal act, that's not within the course and scope of employment and not attributable to the employer, absent extraordinary circumstances.
And generally not foreseeable.
Correct, Your Honor.
Let me ask you this, are you arguing any difference in the preclusive effect based on whether the claim was adjudicated at summary judgment as opposed to dismissal?
No, Your Honor, it doesn't matter under the rule, under Rule 41 and this court's precedents. What's important there is the type of dismissal. So if it's a voluntary dismissal or if there's a lack of jurisdiction, those generally don't have preclusive effect. But if it's a 12b6 dismissal or a summary judgment dismissal, unless the judge provides that the dismissal is not
Without
preclusive,
prejudice.
right, without prejudice, then that does have preclusive effect and is entitled to res judicata deference once it becomes final. And that gets to another point that I wanted to make. You know, the appellants cite the Wharton case, Your Honor, and they argue that that's somehow distinguishable, right? And I think what's going on in Wharton is it doesn't not really about res judicata at all, because that case involved the city of Greensboro and whether it had the authority to issue certain bonds that would take it above a statutory limit. And while that case was pending, Your Honor, the General Assembly changed the limit. There was no final judgment that needed to be given res judicata effect there, so it just doesn't apply here. And I would say the Stevenson case that the appellant cite is the same way. That case involved for a different reason. That case involved successive litigation over districting maps. And a venue decision in one case, in the first case, that was a different lawsuit than a subsequent case, wouldn't be given res judicata effect in the later case, again, because there's not the identity of issues the way that's required for res judicata. So for those reasons, I don't think the authorities that the appellants cite there are apposite, and I would point the court to the decisions we cite, Hogan and Piedmont, in addition to the Plout case from the U.S. Supreme Court, that I think very clearly deal with the res judicata issue that's present here. I'd like to also address another statutory construction argument that I believe the court should consider, and that does not require the court even to get to the constitutional issues. And again, this is an argument that the Child Safe Act and the revival provision just simply don't apply to the appellant's claims at issue here. So as we've discussed, Part 4 of the Act, and specifically Section 4.1, provides that a plaintiff can bring a civil action for claims related to child sexual abuse up until the age of 28. The Child Safe Act is very specific about the effective date of Part 4. If you read Section 9C of the Act, it states that Part 4, which again contains that 28-year limit, Part 4 of this Act becomes effective December 1, 2019, and applies to civil actions commenced on or after that date. That's these cases. These cases were commenced on or after December 1, 2019. So by its terms, what the statute is saying there is that if a plaintiff wants to assert claims relating to child sexual abuse, like the claims at issue here, again, they're relating to child sexual abuse, then that claim must be asserted prior to the age of 28. There's no dispute here that these plaintiffs are decades past their 28th birthday. And that, Your Honors, I would submit is a statutory construction reason that the statute does not apply to the claims at issue before the court, and another reason why the judgment of the Superior Court should be affirmed. For all those reasons, it's not necessary to get to the Wilkes County issue, which is the issue that the appellants and the state spend most of their briefs discussing. And that question is whether or not this court, as an intermediate appellate court, must follow the decision of the North Carolina Supreme Court in Wilkes County, which held that a legislative enactment to revive an action that is barred by the statute of limitations is inoperative and of no avail because it violates the law of the land clause of the North Carolina Constitution. And I think it's telling to read the actual decision from Wilkes County and read what the court there said, because appellants and the state have tried to characterize Wilkes County as a decision based on outdated federal law. But that's not the case. And if you read Wilkes County, you can see what the Supreme Court said after discussing both federal and North Carolina authorities. Here's the court's conclusion. The court said, whatever may be the holdings in other jurisdictions, we think that this jurisdiction is committed to the rule that an enabling statute to revive a cause of action barred by the statute of limitations is inoperative and of no avail. It cannot be resuscitated. That's what North Carolina Supreme Court said about our state's constitution. The Supreme Court, the U.S. Supreme Court, has recognized that Wilkes County announced a rule of North Carolina constitutional law, and that's in the Chase versus Donaldson case that we cite in our brief, where the U.S. Supreme Court described the Wilkes County decision. And what it said about that is that the North Carolina Supreme Court was construing provisions in the North Carolina Constitution similar to the Due Process Clause. And I would also invite the court to review the decisions, and we cited a number of them in our brief, that follow Wilkes County and apply the rule. And I don't think the court will be able to find any of those cases that have treated the Wilkes County rule as anything other than a rule of North Carolina constitutional law. So where does that leave this court? I think for the reasons that I've described this morning, it's not necessary to reach the Wilkes County rule because the statute, the revival provision doesn't apply to the claims at issue in this case because they're barred by res judicata. Construing that provision to void final judgments of the judicial branch would violate the separation of powers. Plaintiffs are past the age 28 cap, and their claims are not claims for child sexual abuse. Those are all reasons that the court should affirm without even reaching Wilkes County. But if the court believed that it needed to reach the Wilkes County issue, then I think the conclusion is very clear, that the court must follow the North Carolina Supreme Court's decision, which has never been overruled. And appellants and the state have some arguments about why maybe the Supreme Court ought to reconsider that, and I would respectfully submit that that's not for this court to review today, and that that decision binds this court if, again, the court believes it needs to reach that issue. And again, this is not an issue where the court should engage in some kind of balancing test. Balancing tests are for situations where the General Assembly passes a law that may burden a constitutional right, but where the law itself is within the General Assembly's authority. But in a situation where our Supreme Court has made very clear that the General Assembly lacks the authority to revive a claim that has been barred by the statute of limitations, you're not talking about an enactment that is within the authority of the General Assembly, where a balancing test would be applicable. You're talking about something that is, from a structural standpoint, beyond the General Assembly's authority to enact. So in conclusion, Your Honors, I believe that the court should affirm the decision of the Superior Court dismissing the claims at issue here. At the end of the day, this case is really a straightforward application of the doctrine of res judicata, which is a deeply embedded principle in our state's legal system. And the court should not construe the revival provision in Section 4.2b in the manner urged by the appellants, that is, to void final judgments of the judicial branch of North Carolina, because that construction would violate the separation of powers. And so the solution I would submit for the court is to construe the statute in a way that doesn't void final judgments. And whatever might be the rule in some other case, whatever might happen in another case where the litigation had not previously been litigated to final judgment, certainly here, where we have final judgments entitled to preclusive effect, I think the outcome is clear under our state's law, and that is that the Superior Court should be affirmed. So unless the court has any further questions, I think I will sit down.
Thank you.
Thank you, Your Honor.
Thank you, sir. Mr. McGee, we have rebuttal time.
Yes, Your Honor, thank you. The defendant says you should not construe the 2-year window to undo prior judgments. It says it revives civil actions previously time barred. If those civil actions are not dead, they do not need to be revived. This provision clearly is in place to do exactly what we're asking. That leaves the constitutional question, but in terms of statutory construction, this says they're reviving those claims. That's why there can't be a res judicata ruling separate from the constitutional argument. Now, when we get to that separation of powers argument, they say, well, that Wharton case, there was no final judgment that was being undone other than an opinion of the Supreme Court of North Carolina. That had been issued. It was sent down for, it's remanded for proceedings not inconsistent with this opinion, and then the legislature changed the rule.
Is Wilkes County still good law?
Wilkes County, first of all, 2 things about Wilkes County. The answer is no. First of all, it doesn't even mention the law of the land clause. They are arguing that Wilkes County says that a retroactive statute of limitations violates the law of the land clause. Law of the land clause is never mentioned in Wilkes County. There is not a case in North Carolina that says a retroactive statute of limitations is barred by the law of the land clause. Second, as an intermediate court, you find yourselves in an interesting position because Wilkes is clearly based upon, and I agree, read it, Wilkes is clearly based upon a miscite of the Supreme Court. So if I'm sitting on an intermediate appellate court, I'm saying, well, gosh, it sounds like they're asking me to recognize that our Supreme Court made a mistake. I am. But I'm asking you to do that because the Supreme Court of the United States issued law that Wilkes clearly misinterpreted. Wilkes actually makes a plain error. It contradicts the Supreme Court of the United States as to federal constitutional law. Campbell versus Holt says it is not a violation of the federal Constitution to have a retroactive statute of limitations. Wilkes, citing the exception instead of the rule, does the opposite. So I understand the situation that puts you in as an intermediate court, but I would say that what you're doing is bringing Wilkes in line with Supreme Court law, Supreme Court, that being of the United States.
Wouldn't that be the duty of the Supreme Court to do that, not this court?
I believe in this particular situation where there's not been constitutional scrutiny ever applied, and where our Supreme Court has clearly applied constitutional scrutiny to due process and law of the land issues before, you would actually be following other cases our Supreme Court has done. Our Supreme Court has consistently applied rational basis or strict scrutiny to constitutional issues that are due process or law of the land clause. And so I think in that sense you'd be following our Supreme Court. I think you'd also be following the Supreme Court of the United States. And right now I think there has to be attention drawn to the fact that our Supreme Court, I think purely accidentally, diverged from what the Supreme Court of the United States said. Quickly on a couple of points of statutory construction. This related to versus for argument. If we're going to apply normal meaning of words, I bring a claim for wrongful death against a trucking company. That doesn't mean I can only sue the driver of the truck. You know, the claim for wrongful death is against the trucking company as well. There's nothing they have pointed to that would show that. They've cited cases that said related to is broad. They've cited nothing to say that for is narrow. There would also be kind of an absurdity that would occur there because the criminal conviction part says related to. So if a priest is convicted, you can sue the diocese. But if a priest isn't convicted, then you can only sue the actual perpetrator, when the criminal conviction has to do with the perpetrator. I mean, that's the kind of absurdity that I think we try to avoid in statutory construction. The other statutory argument he made was that the 2-year window can't allow you to bring a claim beyond 28 years. Then what would be the point of the 2-year window? I mean, the 2-year window was put in front of the House as this is a one-shot deal for older claims to be brought. But if that doesn't allow you to bring a claim above 28, then that part of the statutes competes surplusage. Again, the type of absurdity that we try to avoid. Judge Tyson, I want to speak briefly about the equity point because you've mentioned it a couple of times. Here's what the legislature did. The legislature said there is an unfairness here, and the unfairness is that the actual abuse that occurred to these men is what changed their brains in a way and damaged them so thoroughly that they weren't able to come forward earlier. And so that's why they weighed equities in this case and made a decision to say it's not fair that these guys couldn't bring their claims earlier. And the biggest equity in this case, my clients were chastised for sleeping on their rights last time, for coming too late to the court. And now, if they're denied their right to get to their day in court because they had a previous judgment, now they're going to be told once you were too late and now you were too early. Because once you were too late based on the old statute, and the other time you were too early because you filed before the Safe Child Act. And that would be a terrible and inequitable result.
I ask counsel the question I'll ask you too. Is there a difference between a claim that was never brought and a claim that has been brought and then been adjudicated under the statute?
I do not believe that there is constitutionally here, Your Honor. And certainly when it comes to the Wilkes issue, there's no difference between one that is the law of the land clause issue. The cases that have all been cited all relate solely to any time barred claim and not just to a previous claim. And then I think I've, in the brief and in what I've said earlier, spoken to the separation of powers and why I don't think that there's been any core legislative function, core judicial function here violated by the legislature changing their own rule.
What would you have the court do?
Thank you, Your Honor.
What would you have the court do?
Your Honor, there's two different things we asked for. One is, obviously, and we've talked about it a little bit today, is that the case could be sent to the 3-judge panel, adjudicated there, and then there's a lot of other cases there, and I think they're all going to make their way up through the appellate courts sooner or later anyway. Barring that, we would have the court simply reverse the trial court's dismissal of this case, finding that the Safe Child Act applies to these clients and is constitutional.
How would you have us resolve the plain language of the statute that says, this 4.2B, that says this section revives any civil action for child abuse otherwise time barred, with no mention of previously adjudicated cases?
Because if the legislature wanted to delineate between cases where there was a case and there wasn't a case previously, they could have done that. They're saying any civil action, not just those that haven't been dismissed, those that haven't been filed. It says any civil action. And in fact, in another case, the diocese is contending it only applies to cases that were previously filed. But I think that the language revives any civil action means exactly that, any civil action, whether it's been previously adjudicated or not.
All I got. Thank you.
Anything else? Thank you, sir. Thank you very much. I believe that completes the docket today. Nothing further appearing. Mr. Soar, would you please adjourn court?
All rise.
Thank you for your arguments, gentlemen.
Thank you, Your Honor.
This session of the North Carolina Court of Appeals is adjourned.
Well done. You too, as always. Well done. Thank you. Nice to meet you. Nice to meet you. It's good brief writing. Or you, whichever one of you.
He gets 98% of the credit.